Deed ownership types. Hi, I'm Darren Findling of the Probate Pro. We're going to cover the basic types of ownership when you receive title to property. Now, again, this is just basic information. Please, to your individual circumstances, consult with a qualified attorney that understands the laws within your jurisdiction to make sure you understand how you're owning the property. I'm going to provide some basic information about the various forms of ownership and the effect it can have on your ownership rights. Let's work our way through this. In this particular circumstance, the grantor, the person conveying the property, is named John Doe. He's conveying the property to John Smith and Mary Smith. Let's assume for purposes of this conversation that John Smith and Mary Smith are not married. They're just two family members. They would own the property as what we call tenants in common. So if that information is left blank, tenants in common means that they each have a 50% interest in the property. They don't own it together, and there is no survivorship right. So if John Doe dies, his 50% interest would flow to his probate estate, to his spouse or heirs, or if he has a will, to his devisees. It would not automatically go to the survivor of the two of them, Mary Smith. That's why it's so important that you check the language, because if you simply leave it blank, the default provision is tenants in common. Now let's say you add the language tenants in common. Well, it's obvious that the two of them each own it 50% each. And then if you use the term equally, the same effect occurs. Or the use of the terms equal shares, again, 50-50. Sometimes it'll say John Smith 50%, Mary Smith 50%, tenants in common. Very important to understand the differences between these various ownership interests. What about joint ownership? Well, if they use the term joint tenants, that means they have an undivided interest in the whole. They each own 100%. Upon the death of John Smith, Mary Smith becomes the owner. She's the sole survivor of the two of them. And then upon Mary Smith's death, her interest would flow to her estate. So it is the second to die. And of course, in this particular set of circumstances, if John Smith dies, Mary Smith can do whatever she wants with the property. She can convey it out, she can sell it, or if she dies, it would go to her heirs, not necessarily John Smith's heirs. That's why it's so important to differentiate between a tenant in common ownership and a joint ownership. Again, use of the term joint tenants with full rights of survivorship or rights of survivorship have particular meaning that it relates to this indestructible interest of the two of them owning the property together with survivorship rights. Now, again, we've got another type of ownership, which is called tenants by entirety. It applies to a married couple. In this particular case, let's assume John Smith and Mary Smith acquire the property together as a husband and wife, or maybe they use the term husband and wife. That ownership would be tenants by entirety. There's certain rights that are bestowed upon a married couple based on state law. And of course, upon the first to die, the second owns outright. Now, what about the situation where it just simply says John Smith, comma, a married man, or married Smith, comma, Mary Smith, comma, a married woman without identifying the marital relationship? In most circumstances, that is an individual ownership, and the marital status is not reflective of their ownership as tenants by entirety, but rather their individual interest. Why is this so important? Well, upon that person's death, instead of it going to the surviving spouse, it has to go through probate. So these different types of ownerships, tenants in common, joint tenancy, tenants by entirety, and there are other forms of ownership, are really important to understand the difference. And creating and crafting this deed without thoughtful process of what the intentions are for the ownership, because you can create a lot of really awkward situations. For example, in the situation of a joint tenancy, what happens if the intention was for them to pass it on to the people's children, but instead it goes to the survivor of the two, or vice versa in a tenant in common situation where they each own 50%, if the intention was for the survivor to take, but rather they have 50% of it going to the heirs at law. Very important to understand. Don't just simply leave it blank. Don't just simply write the word joint tenants. Don't simply write the word tenants in common or equally. Be thoughtful and strategic about the ownership, because otherwise you're going to have to contact a lawyer like us here at the Probate Pro and maybe have to administer a probate estate when it wasn't intended. It was simply sloppy deed drafting. If you've got questions about this issue, visit us at theprobatepro.com or call us at 833-PROBATE.